My name is AN-NUR Muhammad LUQMAN HAKIM bin ANUWAR. My metric number 054461. So I will present about chapter 3 about theft. So in the section 6, whoever movable property with the intent of taking dishonestly any movable property out of the possession of another person without that person consent is said to commit theft. In the section 6, punishment for theft, whoever commits theft shall be punishable with imprisonment of any kind for a term of up to 3 years or with a fine or both. In the section 8, theft in dwelling house, whoever commits theft in a building, tent or vessel that is used as a human dwelling or for the safekeeping of goods is subject to imprisonment of at the soft or for a time to 7 years as well as a fine. Next section is theft by clerk of servant property in possession of master. Whoever commits theft in the possession of his master or employer while clerk of servant or while engaged in the role of a clerk of servant will be punished with imprisonment of either sort for a duration that may extend to 7 years as well as a fine. And the last section is section 10, theft after preparation made for causing death, hurt or restraint in order to committing of theft. Whoever commit theft with the intent of causing death, bodily harm or restraint, or the threat of death, bodily harm or restraint to any person in order to commit the theft or to effect his escape after the theft or to retain property taken by the theft should be punished by rigorous imprisonment for a term that may extend to 10 years as well as fine. So for the Islamic jurisprudence, theft is defined in Islam as to take something belonging to another person, stealthy from where the similar things are normally kept, subject to certain conditions. And Islam respect the right of people to own their property and forbids any aggression against this right, whether it is by theft, embezzlement, cheating, bribery, betrayal of trust, of any other way of unlawful taking other people's property. For the Western jurisprudence, I refer to the natural law, which natural law can be quite daunting to understand if one does not learn about jurisprudence, therefore lacks not directly dive into a natural law. We shall begin with developing a rather strong base on what jurisprudence is. Natural law is the model theory of jurisprudence and often state that the law should be on the basis of ethics and the moral. This law also state that that law should focus on what is correct. In addition, natural law was found by humans on their disposition of reasoning and choosing between good and bad. Hence, it is said that this law plays a significant role in establishing a moral and ethical standard.
Assalamualaikum and a very good day. My name is ZAFFRI bin TARMIZI and my matrix number is 055824. Today I will be presenting on chapter 3 of Malaysia Criminal Act Offences 2022. This chapter will illustrate about cheating. The chapter of cheating consists of 5 sections, which includes from the general rule of cheating, type of cheating, the illustrations and the punishment. For the first section that relates to the cheat, it is section 11. It stated that by deceiving another person fraudulently or dishonestly, induce that person to deliver or consent to the retention of any property, or who intentionally induce that person to do or omit something that he would not do or omit if he were not deceive, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation or property. For section 12, the cheating by personation. A person is said to cheat by personation if he cheats by claiming to be someone else, or by willfully swapping one person for another, or by stating that he or another person is someone else than they are. For section 13, the punishment for cheating is stated that whoever cheats is subject to imprisonment of either kind or for a period up to 1 year, a fine or both. In section 14, it stated the cheating with knowledge that wrongful loss may ensue to person whose interest offender is bound to protect. It stated that whoever cheat with the intent to cause wrongful loss to a person whose interest in the transaction to which the cheating relates, he was obliged to protect, either by law or by legal contract, shall be punished with imprisonment, either description for a term up to 3 years or with a fine or both. For the section 15, the punishment for cheating by personation, it stated that whoever cheats by personation shall be punishable with imprisonment of either kind for a period up to 3 years, a fine or both. Moreover, the Islamic jurisprudence in this provision act as a code for living that all Muslims should adhere to, including prayers, fasting and donation to the poor. The Islamic morality such as equality, fairness, justice, freedom and order, it cannot be denied that there are various morality values from Islamic perspective which is very beneficial to humanity. This it aims to help the Muslim to understand on how they should lead every aspect of their life according to the God's wishes. In relating to this part, the Islam prohibits their people from doing any conduct which may lead to bad effect such as cheating in any situation. This is because the Islamic only teach the people to act in a good faith and being good to any creatures in this world. Therefore, the punishment only created for the offender which have a bad faith. On the other hand, for the Western jurisprudence, the most relatable ideology is the socio-logical school. This school laid more emphasis on the legal perspective of every problem and every changes that can take place in the society. Law is a social phenomenon and law has some direct or indirect relation to the society. That's all. Thank you.
Assalamualaikum and a good day to all. I am ATIQAH FARHANAH binti AZMAL. My matric number is 05537. Today, I will further explain on Chapter 4 of our Act, Malaysia Criminal Offences Act 2022, which amounted to rape offence. I chose rape to be included in our Act despite of already having Section 375 of the Penal Code is because the most effective and important approach to prevent rape from occurring to our loved ones are from awareness and education. Only when women understand that rape might happen to them and men comprehend what constitutes rape will help the number of possible rapes decrease. Therefore, it is undeniable that our law is still inadequate to protect women's dignity as well as their rights to be safe in hands. First and foremost, I have decided to include the principle from feminist jurisprudence. From the feminist legal theory, it is obvious through sexuality that men dominate women. For instance, McKinnon gives example of the crime of rape. She says sex is merged with rape. Then, McKinnon emphasized that the very nature of law and legal method is male and therefore the existing law is inadequate to become a good mechanism to serve the needs of women. Following from this, we propound that women should not be dominated by men and that being the case, man should not use his power by putting women as an object to fulfill their sexual desires. In the case of marital rape, it is hard to bring the evidences that actually the husbands are committing rape towards his own wife, but in some developed countries, marital rape or spousal rape has been recognized as a crime. As per discussed, rape occurs when there is no consent during the sexual intercourse occurs, when the wife did not consent to the intimacy due to the fact that she is ill or on confinement period, or just delivered a newborn, that would amount to rape in a lawful marriage. As for the Islamic jurisprudence, in sexual matter, the doctrine of mu'asyarah bil ma'ruf can be applied in marital rape by respecting the need and willingness of the wife in the sexual matter. This means the husband is obliged to fulfill his wife's sexual desires, and on the other hand, the husband shall not force the wife to serve him sexually if she is not ready or unwilling. In Indonesia, marital rape has been ruled in the Domestic Violence Eradication Act 2004. By virtue of this act, marital rape is an offence punishable with imprisonment for a period of not exceeding 12 years or fine not exceeding 36 million rupiah. In Islam, the wife is supposed to follow her husband's commands. However, if the husband demand or instruction contravene Islamic guidelines, such as asking for sexual service when his wife is in nifas, it is prohibited for the wife to fulfill her husband's demand. Secondly, Durkheim's theory of law. He propounded the right to equal treatment, which means the right to be treated equally with the same degree of consent and respect as anyone else. The women are the most appointed gender from being the date rape victim, despite the fact on how they style their outfits. Half naked or fully covered with clothes are all exposed for being the rape victim. Whereas, the date rape in Islam, in Surah An-NUR, verse 30, it is commanded by the Al-Quran that men should lower their gaze and guard their chastity. In order to prevent the date rape to occur, we opine that men should lower their gaze despite the fact on how the woman dress up. Last but not least, as for the punishment of rape within the view of Islamic jurisprudence, most scholars agrees with applying the had penalty for zina to a convicted rapist. This means that the convict will receive a similar punishment for the offence of zina. Furthermore, if a man injures the hymen of virginity, the Shafi'i imposed arch or diya. This is because trespassing on other people's property, which is equivalent to destroying other people's property, must be compensated. According to Ibn Qudamah, if the victim becomes pregnant and dies while delivering the child as a result of the rapist's violence, the offender must pay diya. With that, thank you so much.
Assalamualaikum and selamat sejahtera. My name is NURUL binti ZAIRI. My metric number is 055093. Now, I'm going to explain my part about sexual harassment under Chapter 5. Section 20 specify on the types of sexual harassment. Meanwhile, Section 21 stress on the punishment for those who commit sexual harassment. The reason I chose sexual harassment is because there is no official law on the crime of sexual harassment. In Malaysia, the only law that provides justice for sexual harassment cases is Industrial Relations Act 1967, which only deals with sexual harassment at the workplace. In sociological jurisprudence, Roscoe-Pound understands law as a highly specialized form of social control in a developed political organized society obtained by the application of force of that society. In the current society, the call for sexual harassment being penalized under the law is urgent as it affects the social life. Meanwhile, in Islamic jurisprudence, the Quran prohibited the sexual harassment as it is an action that attack and degrade the humanity and woman's dignity. Islamic teachings on anti-harassment are based on the modesty. The Prophet also said that modesty is a branch of faith. Next is Section 22, which states about the sexual harassment against minors. Many sexual harassment cases involving minors are unreported because of the unawareness on the part of the victim as to whether the action actually constituted sexual harassment, and if so, where to complain and what to do. In Western jurisprudence, natural law is a philosophy of law that focuses on the laws of nature. It proposes that laws are a logical progression from morals. Therefore, actions that are considered to be morally wrong will be against the law. It is obvious that sexual harassment is an action that against the morality of humans. Meanwhile, in Islamic jurisprudence, an Egypt Mufti Shawki Ibrahim Alam said that the sexual violence against women is a big sin and the most disgusting and bad acts in the perspective of the Sharia. It is an action that is out of logical and humanity reason. Last but not least, Section 23, which specify on the sexual harassment in private places. It is very important to acknowledge the existence of sexual harassment outside the workspace. This includes sexual harassment committed by teachers, professors, trainers, or any person who has authority, influence, or moral ascendancy over another person. In sociological jurisprudence, according to LUQMAN, any conduct that shocks people collective conscience is an offence. Members of society are horrified and enraged by the conduct not because of legislation has stated it as a crime, but it is because collective conscience of society is shocked. Meanwhile, in Islamic jurisprudence, it is affirmed that sexual violence is strongly prohibited in Islam because it degrades the human dignity, whether it is the dignity of the perpetrator and dignity of the victim.
Assalamualaikum warahmatullahi wabarakatuh. My name is ROSNANITA binti Rosid and my metric number is 054470. Okay, now I will further explain for topic 6 under Malaysia Criminal Offences Act 2022. In this chapter, there are consists of 6 sections, which is definition of blackmail, type and acts of blackmail, and also for the punishment. The reason why I included blackmail in this act is because blackmail is not only a prominent topic of scholarly analysis, but it is also a common object of criminal prohibitions. Every jurisdiction in America criminalizes blackmail, though with a variety of formulation. Theories about the proper basis for the criminal prohibitions on blackmail range greatly. One reason for this is that, unlike many other crimes, it is unclear who is harmed or victimized by blackmail. According to Durkheim in sociological jurisprudence, the law seems to symbolize the morality of society. Together, law and morality generate an amalgam of ties that bind individuals to society and produce unified and coherent groups. In light of this, he considers morality to be the essence of social solidarity, which is absolutely essential for the existence of societies. Meanwhile, in Islamic jurisprudence, it is not commendable for a Muslim to pursue or expose the mistake of another Muslim. It is also prohibited to threaten or blackmail someone over his deficiencies. The Prophet ﷺ also said, "O people who declare Islam by tongue and faith has not got into their hearts, do not harm Muslims, do not mock at them, and do not pursue their lapse. Whoever follow their lapse of Muslims, Allah will follow his lapse. And when Allah follow his lapse of the person, He will uncover his fault even in his interior house," reported by Imam al-TARMIZI. Okay, as for the punishment under section 29 of this act, according to sociological jurisprudence, a criminal act, according to Durkheim, is one that offends the collective conscience. Members of societies are not astonished or outraged by a conduct simply because it has been criminalized. The objective of punishment is not deterrence, but rather to appease the common of consciousness. A criminal's punishment is reparation offered to the collective feelings of society's members. Okay, according to Hanafi school, gossip is the act of forcibly taking a valuable item from another person without their consent or authority and destroying the honest possession. If someone commits the offense knowingly and intentionally, he is considered a criminal and he must pay compensation. Okay, in conclusion, a healthy civilized society preserves the dignity of humanity. This preservation is apparent in the respect for the rights of all individuals. This respect for rights expresses itself in a variety of ways. The role of the law is to clearly define and identify the law, as well as to give ways and means to redress any infringement by anyone in a way that makes society satisfied. Okay, that's all from me. Thank you.